Despite the COVID-19 pandemic disrupting almost all professional events, on July 23rd, Legal Plus and L2 Icon jointly managed to hold the fully virtual Construction Claims and ADR Conference 2021. The conference was participated by 44 moderators and speakers from 9 jurisdictions. With such a star-studded lineup, we had high hopes the conference would be a success, and true enough, the conference achieved its target by seeing an incredible 1,534 registrations. Not only that, the conference also set a new record in the Malaysian Book of Records for the longest non-stop virtual construction and ADR conference, when the conference ended after a 12-hour marathon at 9 p.m. Although the conference ended on July 23rd, its impact is still ongoing, and it is why we organized this charity premiere, to let the conference see the light of day again and at the same time to show compassion and empathy in our community. Let's watch the show together. It was this experience that became the spark for us wanting to help more people. We approached charitable organizations that help feed the poor, needy, homeless, orphans, abandoned, refugees, mentally disabled children and adults, the handicapped, animals, medical care, and help for children's education by providing used laptops and computers. If there is one thing we learned during the course of this initiative, is that there are many good people in our society, and many charitable organizations are going above and beyond to help those around them. For this charity premiere, we have carefully selected 10 charitable organizations, and we implore you to donate. Even a small amount goes a long way for them. 100% of the funds collected will be distributed equally. This initiative also helps raise awareness, the work these organizations do, and the people they have an impact on. This is the very reason why we are organizing this charity premiere, and with your help, we can help those who help others. It is never an easy decision to make on whether to terminate a contract or to persevere one between a contractor and an employer. None more so during the COVID-19 pandemic that has led to all sort of complications in such contracts. The upcoming show was also the must-watch session of the conference, largely thanks to the enlightening and frank discussion among our panelists that is sure to leave you smiling. Grab your popcorn because the show is starting now.
Session 3 is proudly brought to you by our session partner, James Montero, Advocates and Solicitors. We are honored to have Tan Sri Datuk Seri Panglima David Wong Dakwa as our moderator for Session 3. Tan Sri David Wong was in private practice from 1979 until Tan Sri's appointment to the bench in 2005. Tan Sri David Wong subsequently served as a judge of the Kuching High Court, Kota Kinabalu High Court, Court of Appeal, and Federal Court. Tan Sri David Wong retired as the Chief Judge of Sabah and Sarawak in February 2020. Now, Tan Sri is an arbitrator, mediator, adjudicator, and legal consultant at Chung & Wong Partners. Ladies and gentlemen, please welcome Tan Sri David Wong.
Thank you, everyone. Good afternoon to everybody. May I start off by congratulating the organizers for this record-making webinar, and more particularly in doing a charity drive, Caring is Sharing 2.0. Doing our little bit, I'm glad to announce here that this panel has committed to donate a laptop to that cause. Sui will follow up with the organizers on this commitment. Now, reverting to this session, now there's a reason why these three speakers, namely Havans, Sui and Kohindran, are slotted in this lunch session, which I may say the most difficult session to capture the attentions of any participant, as he or she would be yearning for his lunch, for their lunch. But for myself, I'm not worried at all. We have three speakers who are not only knowledgeable in this area of law, but also known for their unique and endearing style of presenting their address, which will no doubt divert the participants' foot yearning back to what they're saying. The topic, termination or determination, I would imagine is a topic which many in the construction industry would be facing now in view of the pandemic ravaging our country. The topic brings into focus the COVID Act 2020, which is now extended to 31st of December 2021. It is under this cover that termination and determination will be discussed and demystified by the speakers. The issue of availability of judicial review will also be discussed in the context where government's contracts have been terminated on the ground of national security or public policy. How Cpa is played out when there's a determination or termination of a contract will also be discussed. Whether parties should consider the cost benefits in going to adjudication, arbitration, and courts will also be discussed. On that note, we're going to start here, but before I invite the speakers, we are going to do a poll. Could the organizers just show the poll? The question is, have you been terminated or have terminated someone since March 2020? Okay, we just leave that poll there for about 30 seconds to a minute, and then we will start our session. Okay, I think that's enough time for the poll. Organizer, are we showing the results now or show it later? Oh, okay, that's interesting. Seems that the no answers about 84%. Okay, great. That would set the tone for this session. Okay, without further ado, I now call on the Habans to take over the floor. Thank you, Habans.
Okay, good afternoon, ladies and gentlemen. Thank you very much, Tan Sri, for introducing me for this session, and also thank the organizers. Now, this is a very wide and difficult session, but the problem is I will try to introduce the topic, okay? I will try to introduce the topic as much as I can. I do not know whether I've been able to I'm able to, whether you're able to see my slides or not. If you're not, then I think I'm having a bit of a trouble opening up my slides. Anyway, I will. Okay, I will start off with this topic now. I will introduce the topic first. Can I have the next slide, please? Okay, determination and termination actually has been used interchangeably in this in the industry. The problem is there's a lot of confusion in the market regarding this topic, but basically it means the same, is bringing to an end. Different authorities have got a different viewpoint on this matter. If you look at Chow Kok Fong, he believes there's a difference between the two terms. But if you look at Hudson's, and even if you look at our Justice Datuk Lee Swee Sing's decision in Econ Pal's case, basically the majority opinion is actually the practical effect is the same, whether you call it determination or termination. Okay, because in both cases the primary obligations comes to an end. Okay, can I have the next slide, please? Okay. Sorry, yeah. So now, in determination and termination, actually there are two different categories of determination and terminations. One is with default and the other one is without default. Okay, the one you have with default is the ones we are having with performance defaults, financial defaults, or for government contracts and corruption and bribery. Yeah, this topic will be dealt with by Mr. Kohindran. Okay, I will look at the other one, termination or determination. That is basically without any fault on the part of any of the parties. Can I have the next slide, please? Okay, determination or termination without default. Actually, here there's no any breach or default on part of any one of the parties. In the contract, there's a clause. Okay, and here we have three different kind of types of determination without default. The first one, the one which is most common, I think some of you have come across in, I think in the JKR contracts we have, is mutual determination or termination. And although a lot of people overlook this fact, this is one of the determination termination where actually there's no default on anybody's part. It's like going for a mutual divorce for that matter. Okay, so it is beginning to feature in a lot of contracts. In fact, the most recent AIEC contract, we also have this provision put in because it really helps you. Now, the only problem starts when you don't have such a provision and both parties want to actually mutually bring the contract to an end. Then what do? So normally what you'll end up doing is having a supplementary contract. Now, the other two type of contracts have slowly begin to feature now in our most of our contracts. And if you look at, for example, the CIDB 2000 contract, almost 20 years ago, we had something called termination by convenience, or what we say termination without default. Now, this has also been picked up in the IEM civil engineering form, where it is put in as an option. And lately, we have put it also in the AIAC design and build form. And the reason why I'm talking about it is I've actually done about 2 arbitrations involving termination by convenience. And one was a fast track arbitration post COVID pandemic. And that's the reason why I think we have to put a little bit of emphasis on that. And of course, a lot of people are not aware that in the government contracts under JKR, we have also such a provision, but they don't call it termination by convenience. Actually, they call it termination for national interests. And it goes like that, the government can terminate you under national interest, national policy, or national security grounds. And if you look at the clause in the contract, it says that whether it is national interest, national security, or national policy, it is decided by the government, and the decision is final. And this is something which you're going to talk about in the panel discussion because we are already beginning to have cases now coming up. Okay, can I have the next slide, please? Okay, now mutual termination and determination. Now, what are the practical issues and difficulties? In fact, unless this clause is actually properly drafted, it can give rise to a lot of problems. I've done an adjudication on that, and I've also done an arbitration on that. And the important things you have to look at is, first thing you got to decide which party has the right to initiate. Actually, both parties got equal right, but normally one of the parties got to initiate. And under the pandemic situation now, we find is mostly the contractor or the subcontractor who's actually asking to initiate this provision. And then what happens if there's a lack of agreement? You ask for mutual termination and the other party says no. Okay, so what do you do with it, And here, this is where the problem starts, Although you have a mutual termination clause and then one party is adamant about it. And we have been seeing that a lot in our post-COVID pandemic situation, where a lot of contractors, because they're having financial difficulties, prices have gone up and all that, they would rather go for a mutual termination. But the employer doesn't want to because he still feels it's not in his advantage to go for mutual termination. And it has created some sort of a problem. That's an impasse. But the problem about a mutual termination clause is, unless both parties agree, you actually cannot actually evoke this clause. So this is one of the issues, I think, which is becoming quite contentious at the moment. Okay, and then again, if there are any conditions precedents that must be met, you have to make sure, because most of them are written in very mandatory language. And some of the provisions are in the form of notification. The intention of one party, okay, one party to initiate this clause to set the whole process going. And then again, this question of people are getting sticky about a mode of delivery, and you can understand under the our pandemic situations, we cannot have the conventional modes of service. So here again, there are some contentious issues coming about. Okay, and then the next problem that starts up is the post-termination and determination. Okay, what happens once the parties agree they want to mutually terminate the contract? Now, the biggest problem is finalization of account. We all know that finalization of account, even in conventional cases, takes a lot of time. Normally, they talk about 3 months. It doesn't take 3 months. And one of the biggest issue is measurement of work. And we know under the COVID situation, there can be no physical measurement of works. So now how do you go about doing it? Can you do it remotely? And one of the solutions they've afforded is you do from the as-built drawings. Okay? And again, the problem comes about as-built drawings. The drawings are not actually updated progressively, and this has given rise to a lot of problems. And this is one of the issues perhaps we can discuss in the panel again, where we are talking about finalization of account on an elemental basis. If you go along this basis, then once you terminate the contract mutually, for example, you will be able to finalize the account and then pay off the contractor. Because now what is happening in a lot of scenarios, although they have mutual termination, but they cannot finalize the account and the contractor cannot get paid, is leading to a lot of payment issues. And this ties in second issue, payment of the final sum due. It doesn't happen. And I know 2 or 3 cases now, parties are trying to initiate adjudication, which defeats the whole purpose of going for mutual termination. Now, the other thing is talking about the contractors, subcontractors, other financial entitlements, okay, and the failure of one party to honor. And what is happening is most employers are already cash tight and they cannot meet the timelines. And now we are having consequential dispute resolution mechanism coming in. And contrary to what I heard to what was discussed in the previous session, there are a lot of ad hoc mediations actually going in. Parties are talking. It's not true to say parties are not talking. In fact, I've been involved in a lot of mediations where parties have been trying to come to an amicable situation following mutual termination of a contract so that they can finalize, they can collect the cash, and then the party can move on. Okay. Of course, the other issues that are coming about is issues to do with warranties offered by equipment manufacturers. Now, are these warranties still valid when the new contractor takes over? Or is the replacement contractor later on, if the employer wants to start doing the work again to another contractor, even after mutual termination, are these warranties still valid or not? So these are kind of these issues that are coming up, and also issues to do with latent defects. Okay, can I have the last slide now? Now, crystallization of the right, termination by convenience. This is actually, a lot of people say it's one-sided. Only the employer is given the right to actually terminate whenever he likes. And a lot of employers who have these clauses in their contract are actually exercising it. They know it is very difficult to carry on with the contract. I might as well bring it to an end. And here again, you see, notification is very, very important. The termination is very, very important. And then a lot of challenges are coming to this. In fact, in the arbitrations which I encountered, we have challenges to do with notification, the very fact that it is not done in good faith. And as you know, these kind of clauses are actually very strictly construed. First thing, they're construed contra pro frentem. Second thing, if you follow the Chatajaya's principle, they're very strictly construed. And then this is where we may have to, in deciding whether the termination or determination was actually done properly or not, we may have to apply principles, for example, principles of good faith in Berganza's case, which we'll discuss later on in the panel discussion. And of course, we are going to talk about the applications, advantages and disadvantages again in a panel discussion. I'm just giving you the overview first. And then again, we have the same problem as for mutual termination here for termination by convenience. The final account is not finalized in time. The contractor is not paid in time. A lot of issues are coming up. So can I have the next slide, please? Okay, now the way forward, we have to look which way are we going to go now. Now, the tendency nowadays is a lot of people are drafting the clauses are allowing for all kinds of possibilities now. You cannot just go on default anymore already. you also got to look at this kind by convenience or whatever it is, because the situation is changing very fast. And in this post-COVID era, for example, this era is not going to end very soon, and we may have another pandemic coming on. So here, I think a lot of flexibility should be built in. And this is why I feel instead of one-sided contracts being imposed, I think input from both sides to be needed. And I think a lot of standard forms need to be revised. We started off with the AIAC form, is quite flexible, okay? And I think we have to start looking at a lot of other forms, okay? And of course, the other issue we got to decide is how to resolve the disputes and claims. If you ask my personal opinion, I feel statutory adjudication under Cpa is a failure, if you ask me, in terms of time-wise and all that. And I've been advocating mediation, although a lot of people don't believe in mediation. Let's give it a chance to work. And that was what the government also intended when they came up with the COVID Act. So if we are not going to do it in the COVID era now, if we are just going to insist on our right, and I think we are not going to resolve the problem, because we have to go for a win-win situation. We just cannot look selfishly for one point of view. Okay, so here I think common sense and good faith can prevail. I know our society is not built on good faith. Our society is inherently unfair. It is a fact, okay? But in the industry, all of us are involved, regardless of our religion, regardless of our race. All these things, issues should not come in. It should be for the benefit of everybody, okay? The stakeholders, the government, and of course, at the end of the day, the public at large. So with that, I thank you very much. Sorry, I have to rush through it, okay? So I want to pass the thing now on to Mr. Kohindran, who will talk about termination by default. Mr. Kohindran, can you please take over? Thank you.
Thank you, Harbans. Let me try and share the screen first. Can you guys hear me? I hope so. Right, and I hope you can see the screen. Right, thank you. Good afternoon, ladies and gentlemen. I'm not sure if my 15 minutes will be even remotely entertaining, pardon the pun, over lunch, but let me try. Hopefully all of you keep your food in now, okay? Now, to deal with the question of whether or not you need to determine or terminate the contractor's employment, or whether these rights are actually different, one needs to look at the interplay between a contractual termination versus what is generally known as a repudiation of the contract. Now, in terms of contractual termination, I have found a useful passage from, again, Chow Kok Fong. Okay. So what he says is contractual termination is based on specific terms of the contract. The right to terminate basically is exercisable on a breach. And so long as termination requirements of the termination clause are satisfied, there is no necessity to see if the breach amounts to a repudiation. In fact, he says it would not even matter whether the event would normally be considered as a breach. Now, insofar as repudiation is concerned, what is normally described as the common law position is actually governed by Section 40 of our Contracts Act. This basically provides that if a party to a contract has refused to perform its obligations, then the other party may put an end or terminate the contract. Now, Malaysian cases have dealt with the interplay between contractual termination and repudiation. I want to highlight a couple of these cases. The first case is the 1998 High Court case of Malayan Flour Mills, case involved an application to set aside an interim arbitration award of the late Justice Datuk Seri George Sia. Now, in dismissing the application, the High Court held that since the notice of termination cited a ground which falls under the termination clause, the employer could not resort to the common law termination for a repudiation remedy. Now, conversely, if I take you down to the next case, which is SPM membrane switch, a federal court case, Now, this case involved the termination of a concession or privatization agreement where basically the Selangor state outsourced the collection of quit rent to a private company. The state then sought to terminate the agreement under a termination clause for non-performance. The High Court and Court of Appeal upheld the termination. Federal Court overturned the decision, holding that the termination was not properly exercised under the clause. But in passing, the Federal Court made these obiter comments on the relationship between common law and contractual termination. Now, although the Federal Court stated the rights of termination and common law and contract may not coexist unless the contract provides that the contractual rights are without prejudice common law rights or words to that effect, the Federal Court also stated that even in the absence of such words, a party may still rely on both contractual and common law rights. So I think this sets the stage for us to just look at some cases after this. Oh, just give me a minute. Right, the first of the cases which I wanted to illustrate is a case called Newland and Toba. Right. So in this case, Newland and Toba entered into a contract for the sale of gas oil. Clause 7, which is there on your screen, provided that Newland could cancel the contract if Toba failed to pay for the cargo within set period. Newland shipped the goods, pressed for payment, Toba failed to pay, Newland served a notice terminating the contract. Now, the termination contract referred to the terms of clause 7, but also stated that the breach was recognized as a repudiatory breach. Now, the judge held there could be 4 possible ways of interpreting the termination notice. The contract was terminated under clause 7 only. The contract was terminated under common law only. The contract was terminated under both clause 7 and the common law, or that the contract was not terminated at all. Now, the judge concluded that the effect of the notice was to constitute a valid exercise of both the right to cancel under clause 7 and the right under common law to terminate on account of repudiatory breach. But he did not stop there. He went on to say that if it was not possible to exercise both rights concurrently and one had to elect, the conclusion would have had to be that by purporting to exercise both rights, Newland actually did not succeed in validly exercising either, i.e. they did not succeed in terminating the contract at all. Now, a strange and curious result, but thankfully, such a result was avoided because of a subsequent notice which the judge held was sufficient to terminate the contract under clause 7. Closer to home, we have a case, Justice Datuk Lee Swee Seng's case when he was sitting in the High Court. This case involved the construction of UTM campus in Melaka. Disputes arose between the parties, leading to the suspension of the works by the contractor for non-payment. Default notice, 14 days default notice was issued on 13th of July under clause 25.1, suspending works without reasonable cause. Sorry, actually the contractor suspended the works because of non-payment. Okay, so then on the 3rd of July, a default notice is issued by the architect under PAM because the contractor suspended works without reasonable cause. On 13 July, even before the lapse of the 14 days, employer issues a termination letter. Now, the letter referred to the notice of default, but also went to say that the suspension without cause was a repudiatory breach, which entitles the employer to terminate. Now, Justice Lee held that it was incongruent for the employer to terminate the contract forthwith under common law and at the same time seek to avail itself of rights available upon termination of the contract. He seemed to be persuaded by the Malayan flour mills case, if I'm not mistaken. I think that in any event, the High Court was clearly right to hold that the termination could not be justified under the common law, considering that the time frame under the default notice had not yet expired. They prematurely terminated. Maybe it may have been different if they waited and terminated after the 14 days. Now, The next case I want to refer to is a UK case. Case between Phones for You and EE. Now, Phones for You was a well-known retailer selling mobile phones and mobile contracts to customers. EE is a major mobile network operator in the UK, and it sold its services to its customers through Phones for You. The relationship was governed by a trading agreement. It was supposed to run until September of 2015. Then Phones for You's business was facing difficulties. Various people were terminating their contracts. EE also notified that it would not be renewing the trading contract. Phones for You shortly after that ceased trading. EE then terminated the trading, they ceased trading and administrators were appointed. EE then terminated the contract under clause 14 as administrators had been appointed. Now, although cessation of trading by Phones for You was a repudiatory breach entitling EE to terminate, the court held that based on the termination letter which was issued, EE was only terminating in exercise of rights under the clause and not for any repudiatory breach. And even though EE stated in the notice that nothing in the notice shall be constituted a waiver of any rights, the court held that that was merely reserving your right. It was not exercising your right. The court held that EE could not recharacterize the termination as if it had terminated for repudiatory breach when they simply did not do that. Now, the last case I want to refer you to is a 2021 Hong Kong case where a Hong Kong company which was carrying on aircraft chartering business entered into a contract with the defendant, a mainland Chinese company. They entered into a contract under which the defendant was supposed to, the defendant agreed to charter 100+ flights between Chongzhou, hope I pronounced that right, and Chicago. Plaintiff issued an invoice for the charter flight, no payment was made. Defendant said it was considering postponing the contract and did not pay. In the end, the plaintiff issued a termination letter under clause 9, and this was what the termination letter said. It referred to clause 2.3, which makes it clear that payment is of the essence. Termination letter, just like the previous case, the Phones for You case, also made a reservation of rights, including but not limited to rights available under contract. The court held that it was satisfied that the plaintiff did exercise both its contractual right to terminate and its common law right to accept repudiatory breach. The court also noted that the reference to payment being of the essence in the termination letter and the reservation of rights in it all suggested that the plaintiff did have its common law right to terminate in mind and did not merely intend to rely on the clause under the contract, clause 9. All right. Now, we have seen the interplay and the cases on common law and contractual termination. So going back to the question at the outset of whether or not you need to terminate or determine the contractor's employment, or whether these rights are different, at the end of the day, it does not matter whether it is termination, determination, cancellation, forfeiture, or whatever other terms one uses. The real issue is whether you're exercising your rights under the contract, in law, or both. Although the rights are different, I think generally a party can rely on both contractual and common law rights. Now, why is this important? It is important to have this option, especially when, as Harban said earlier, courts are now looking strictly when it comes to a contractual termination. So your contractual termination might fail, but you can still save your common law termination. With that, I hope my talk has explained some of the considerations to be taken into account before terminating under the contract. I hope you have kept your lunch in. Terima kasih. Over to Sui. I'll stop sharing.
Thank you very much. So you've heard Harban's talk about terminations without default. You've heard Gohindran talk about terminations under the common law and also with default. And I would like to now turn to having a look at some of the effects of termination on dispute resolution. you've heard both these talks, and really subject to you having a mutual termination that's been sorted out wonderfully, you are going to end up in a fight. That's what termination, forfeiture, bringing to an end that contract, that's what it normally results in. We all know, and something we talked about this morning as well, fight equals money and equals time, and this is a major problem. So what is it that we are normally dealing with when we talk about dispute resolution post-termination? Usually you'll have a contractor making claims for work done, variations. Often the termination is not at the end of the contract, which means to say you've got to deal with supply contracts and vendor contracts that are terminated halfway through, or midway through, I should say. So you have materials that are ordered, you have equipment that has been ordered, especially your long lead equipment. Then, of course, there's the usual claims that we've talked about today, loss expenses. And quite often, we also see claims such as loss of profit. On the flip side, you find your employers obviously making claims for defects, extra over completion, cost, delay damages, general damages, all that kind of thing. So with all these difficult things and all these issues that come into play, I just wanted to just consider a few situations as to the impact of termination, and in particular with dispute resolution. These will range from tactics to jurisdiction, from commercial considerations to liability. I'll start off with Cpa. So there was a lot of talk, for example, this morning with the standard form contracts. And it is very, very common that when you have a termination under a standard form contract, then you have a situation whereby the employer terminates, the employer doesn't have to pay the contractor until after the new contractor takes over and the works are completed. Only then you have this payment. And typically, clause 25.4D of the PAM4 contract provides for that. We also have heard today about a federal court decision, a court decision in IRDK against Ecompile, where this was considered within the context of Cpa. And basically what it was said there was that it is tantamount to a conditional payment that is prohibited by Section 35 of Cpa. Now, this matter went from High Court to Court of Appeal, and I understand from Wailun that this is now fixed for hearing before the federal court next week, on the 2nd of August. But I also have been told that it may or may not go on because actually the arbitration has been completed. So the point I make here is that in this situation, there is still uncertainty because as this thing wends its way to the court, it may land up in the federal court and you get a decision there. But that's not to say, as we have also seen today with the consideration of various court cases, that the law may change. So the point about this is that in this particular case, you may actually end up with a tactical maneuver. And I've seen this many a time sitting as a Cpa adjudicator, whereby a payment claim is made or submitted, and the non-paying party, often with advice of lawyers, will quickly initiate a termination and then raise as one of the defenses this clause 25.4D or its equivalent, which then immediately brings an additional type of argument and possible defense onto the table. So this is one of the tactical type of issues that may occur, and you need to be careful about that. Another one is one of jurisdiction. Again, just using Cpa as an example. Very often, as a result of termination, there will be a claim not just for work done, but also for general damages. And we have seen that general damages will fall outside the ambit of Cpa. So you are limited in what you can or cannot claim. And that therefore raises a jurisdictional issue. Another jurisdictional issue that has been tested in the courts is that of use of Cpa post-termination. Now, happily, that has also been decided by the federal court in the case of Matego. And in fact, Court of Appeal, at the Court of Appeal stage, our Tan Sri moderator was one of the Court of Appeal judges there. And the issue there was whether you could use Cpa after termination but in respect of claims that were accrued prior to termination. It was a ding-dong battle, but it went finally to the federal court and it was decided that yes, you can use Cpa. Another area where the termination comes into play and you have to watch out for is termination for insolvency. Now, termination for insolvency is not something that is extremely widespread in its use thus far, but I think that post-COVID, we may be seeing a little bit more of that. First and foremost, you know that if there is an insolvency, then in order to proceed, take legal proceedings against the insolvent party, you need leave of court. The insolvent party is then being handled by the liquidator, who has got very, very different type of objectives in mind in comparison to a company that is still solvent and still operating. So, for example, in one situation, I was the arbitrator, and one of the parties went insolvent. In this case, it happened to be the respondent, and for their own commercial reasons, the claimant sought leave and got leave of the court to proceed against the insolvent party. But we couldn't proceed yet with the arbitration, and it had to be put on hold, awaiting the liquidator's appearance. Now, what happened was that there was a long lull and there was no word from the liquidator. Finally, the liquidator came back and told us that they held a creditors meeting. Basically, nobody turned up, and there was no interest and no appetite to carry on with this arbitration. So what had started out to be a hotly contested arbitration ended up as a damn script, as an ex parte or one party held only arbitration. So there was quite a dramatic change as a result of a termination and the insolvency issue. There is another celebrated case that is not in Malaysia, and it was a very, very large case, a mining case, where the main contractor was a unincorporated joint venture. What happened was that one of the joint venture parties was insolvent, went insolvent. The employer then terminated the joint venture. So the question there was whether one party being insolvent, did that render the entire joint venture, which was the main contractor as such, insolvent? Over $1 billion turned on that question as to the right or wrong termination. So these are the sort of things that one has to consider. Of course, whenever you go into dispute resolution, the more issues there are, the more complicated it is, the more time it takes, the more money it takes. And cross terminations often arise, and they are such complications. You've heard Devon talk about it. A typical scenario would be that, okay, contractor has not been paid, either not been paid at all, not been paid enough. Terminates for non-payment, stops work. Employer comes in and says, oh, that termination is wrongful. Your stoppage of work is wrongful suspension amounting to a repudiation, and cross terminates based on that. Another common scenario is where a contractor has not been paid or not been paid enough, and he just suspends work. Often he hasn't even consulted his lawyers or taken any advice from himself. Again, employer treats the suspension as an event of default and terminates. So now you've got cross terminations that are being argued in the arbitration. Obviously, with that, there are more complicated issues to be dealt with. And a lot will then turn on that single point of termination. Now, anecdotally, many years ago when I was acting as counsel, we had exactly that situation. And our arbitrator ended up saying that both terminations were wrongful, which left us in a quandary, because if both terminations are not wrongful, it would appear that the contract was still in existence. Luckily, nothing came out of that, and we'll see what happens. But another issue, as I said, that comes out from termination often is the claim for loss of profit. A party who has been terminated says that, you know, I was not given a chance to earn the profit by completing this project, and makes that claim. Now, we all know there's a lot of discussion about that. We're all discussion about how difficult it is to quantify loss of profit or indeed prove it. If you look at the federal court decision of Panglima, that issue then translated further into whether the arbitration award could be set aside, because in that particular case, the arbitrator used his own industry knowledge to determine the amount of loss of profit. So these are the types of things that we see. And the other thing that we have to consider, as we've been talking a lot about today, especially in this current time, is the practical impact of termination and commencing dispute resolution. If you've been terminated as a contractor, you then actually don't get paid. And yet you have to spend money, spend time, and spend effort to pursue your case of wrongful termination. Time, money, cost. Of course, there was some mention about third-party funding, and I know that Cheng Yi will be talking about that later, so I won't go further with that. But this is, you know, these are sort of practical aspects that we have to consider. Even the application of liquidated damages is affected by termination. Colin is going to be dealing with that later, but I think that the recent case in the UK Supreme Court of Triple Point against PTT is of importance here, and I'll leave Colin to deal with that. But my point is that termination played a role in determining how you can or cannot impose LDs. My conclusion on all of this is basically that, look, you have got to pay attention to the termination clauses. You've got to get advice so that you don't do it wrongly. You got to get advice in a timely manner so you don't get outmaneuvered. You don't have a second bite at the cherry. Once it's done, you're in dispute resolution and you are dealing with all these complicated things. There are also situations where, again, anecdotal from my time as a counsel, you terminate for commercial reasons. You may know, for example, an employer as a developer, and he's got a non-performing contractor, terminates the contractor for default, knowing full well that his grounds may not be the most solid. But by doing so, what he does is that he ring fences that issue into one that is legalistic and dealt with in arbitration. In the meantime, on the ground, he is able to finish up his project and deliver to the purchasers. And the arbitration then proceeds at its own pace. All I'm saying, ladies and gentlemen, is that termination is such an important draconian thing. It's time and it's money. And in today, time and money may equal survival. When I first started as a construction lawyer 30 plus years ago, termination was practically unheard of. But today, it is something which is quite common. It is often used, and therefore, I think it must be discussed and considered and at the forefront of our minds. So thank you for that. And I want to thank also Legal Plus and L2 for inviting me onto this panel. And a special shout out to Cindy Wong, who has shepherded us all with military precision. Thank you. Back to you, Tan Sri.
Thank you, Sui. Let's get straight back into business. We're talking about termination, determination. I think we have to discuss this in the context of the pandemic. So my first question, maybe to Habans, is can termination of contracts and subcontracts be carried out by the employers, main contractors, and subcontractors premised on the grounds of COVID-19 pandemic? If such a determination or termination is undertaking, is it legally valid? And what is the effect of the various COVID Act regulation issued by the government on the validity of the determination, termination, and can the latter be properly challenged? Avans, over to you.
So, Tan Sri, I think I will leave this question to the legal eagles. You know, I think I'm a bit underqualified to answer this. I think I will get their input first. Maybe I
Okay.
can comment on the practical side only. Okay.
Okay.
We don't mind.
No problem. Devan, you want to jump in?
Again, I'll try. Under Section 7, basically, if a party is unable to perform its contractual obligations due to the measures prescribed by the Prevention and Control of Infectious Diseases Act, then that shall not give rise to the other party exercising his rights under the contract, which means that if you were unable to perform your obligations due to the PKP regulations, for example, the other party cannot terminate the contract. There is a saving provision if you had terminated this contract before the act came into force in October 2020. Yeah, so that is the position. So I think, so if you terminate, obviously it's wrongful termination and the other party can sue you. Yeah, so
Well,
that's
let's talk about a situation where the termination is done now.
Yeah.
Well, I mean, the Section 7 provides you can't terminate due to COVID.
Yeah.
Now, the question, just to lead up the question, now, if people go to adjudication, arbitration, now, who would determine that question? Will it be done by the adjudicator, the arbitrator, or can parties go straight to court to determine that, look, that termination was wrongful because of Section 7?
Sri?
I think that if it came before me either as an adjudicator or arbitrator, I would have to deal with that question in light of Section 7. And I personally find Section 7 quite vague, and I think that I would need a lot of guidance from both sides arguing the matter to be able to come to some sort of decent decision. Because at the end of the day, I think that this is actually a question for the dispute resolver as to whether that termination is rightful or wrongful. So it's going to be an interpretation of the statute in light of the factual circumstances. Yeah.
Are any of you aware of any cases on this matter in court? There isn't, is there?
Well, there is a case, but not related to termination, where someone tried to use the act. It's called a WRA Services versus Protocol, where they said that they were not able to pay, but actually the payment was due in just before March 2020. So the court held that they could not avail themselves of the protection granted by the act.
Because the phrase there is very wise. It's due to, you know, is it partially or materially? If you were advising somebody, would you say, look, that question should be determined by court? You go straight to the court, injunct the proceedings of the arbitration or adjudication. Would that be a correct route to take or advisable route to take?
Who is the question posed to?
You're practicing.
Oh, okay. So I don't think that's a jurisdictional issue. So I think the adjudicator, it is well within his purview to decide the matter. Just on that point, actually, the COVID Act does have a provision under Section 9, which talks about any disputes being resolved by mediation, but it's got no teeth, you know, at the end of the day. Yeah.
Okay, Habans, please jump in.
Okay, so after the legal eagles have spoken, I just give the feeling on the ground what is happening. Because of this uncertainty, and people don't have time to go to the correct tribunal to decide on the interpretation, because let's be very frank now, the situation on the ground is very fluid. You know, we are sitting all in our high lofts. We are making a lot of theoretical things. On the ground, the situation is very different. People are dying. They're not getting the cash flow. Things are not moving. And on the other hand, you have an employer or main contractor where you have 10 or 20 subcontractors, each coming to you because you can't pay. And then you have this all X flying around. Yes, there's a lot of legislation in place. But I think what the people want is less law and more practical things on the ground.
Yes.
And that was the reason why I said that adjudication is not working under Cpa. Let's face it, you file things, you want to go to arbitration, you want to go to court and all that. How long is going to take? And that is why I think what is happening on the ground, yes, they said you may go to mediation, okay? But a lot of people are not going to formal mediation because of the bureaucracy. But I think a lot of people are still making attempts to try to resolve the matters on the ground. And this is what I think we should encourage them to do.
Yes.
Because if you really don't have money, you cannot carry on with the job, then what the hell? No point suing me. No point taking me to adjudication. You see?
That brings me, yeah.
Yeah, and on the other hand, you are a guy that, if I go to court and this and that, it's going to take me a hell of a long time, even adjudication. Everybody keeps on appealing. You wait until a federal court makes a decision is how many years? Even if I can get 20 cents out of the dollar now, and I can pay my worker the 20 cents, I think this works. So these questions, I know is very relevant. Legally and all that, I think we can look at it later on, I think so. But on the ground, what I feel is we should try to encourage people to try to resolve the thing amicably as possible. And that's what I said, win-win situation. Because contracts are being terminated. It's the truth of the matter. Some not even formally at all, they just abandon the job. They say, go ahead, lah. You can do anything you like, I mean, so it was in that context I'm answering, I know. I let the legal eagles answer.
No, I mean, it's very hard to dispute what you're saying, Habans. But that brings me to the questions.
Yeah.
I mean, Singapore, and I know Australia, makes mediation mandatory.
Yeah.
Right? Unless you make it mandatory, people, one side of the legal ego come and say, hey, let's go to adjudication. So I really do not understand why the government is not making it compulsory.
No, and that's the reason why Tan Sri, the so-called, even AIAC, I think, set up free doing pro bono mediation. I think the take-up rate is very low, because, the big boys somehow, let's say, the first layer, main contractor, subcontractor, employer, they have access to all kinds of legal means. They can go to adjudication, this, that, and all that. But the small timers are the ones, and the small timers are somehow scared of bureaucracy. And this is what, just to let everybody know, on the ground, there's a lot of ad hoc mediation and negotiation going on. So in a way, in the pandemic situations, we are having a lot of determination and termination at the lower levels. And at the lower levels also, I think there's a lot of resolution going on quietly.
Oh, that's good to hear. Yeah.
That's right. If I can just jump in there, because I lived through the 1997 Asian financial crisis, and the outfall there, especially from a project that I had been seconded to for 2 years, which is the KLIA project. I mean, in those days, mid-90s, KLIA was a big deal. So although the 1997 Asian financial crisis was not as widespread as worldwide as our current COVID situation, but there are certain parallels and perhaps certain lessons that could be learned from there. First of all, it was a gentler time, really. I mean, the people and attitudes then, I think, are a little bit gentler compared to today. The other thing about it was that there was a feeling that it was a national project and had to be finished. So there wasn't so much about you, me. There was just more everybody was in it together kind of feeling. And ultimately, there were construction contract provisions. And I know them very well because I was part of the drafting team, and every time I walk anywhere, everybody will say to me, you are the one who's responsible for these really difficult, these really tough conditions. But at the end of the day, it was all about jaw, not war. And at the end of the day, it was also about, as what we was talking about today, we're all in this together. You want this project built, you actually spread the pain because it wasn't any one party's fault. We're all in this together. Now, whether we can actually get that type of sort of community feeling into a more widespread manner, I know we've heard the speakers this morning so far say that not so much today. But how do we get that sense of community back into play?
Tan Sri, just one point. I know Harbans is talking about the ground, but I mean, we just saw that the poll results. Obviously, not everybody's contracts are being terminated, so perhaps it's not all gloom and doom as painted. I know you're a rock star, right?
Let me interrupt you here.
Yes,
because the people who are actually affected, have not paid up to come as participants here. We are only dealing with a very small portion of people. These are the privileged few. Let's face the facts. The people down the ground, they don't have that, the luxury of attending these kind of forums. They are the ones having the problem. And as I said, let's forget about the politicians and all the so-called eminent people and all that. Kita kena tolong kita. We are in the construction industry. The construction industry survive, we survive. And this is where I think our input should come in. You see, and if we can help to resolve it, why not? I know people dig their heels, but sometimes you have to talk sense to people. I know arbitrators want work, adjudicators want work, lawyers want work, but in this pandemic situation, I think there's enough work for everybody. But you have to be on touch with the pulse on the ground, and a lot of these people down the line, they can't afford even any kind of legal advice, this, that, and all that. Our legal aid bureau, let's forget about it, is nothing, it's only in name only.
Okay.
And all these things.
I want to sorry. Just say that I rest my case. I said in the beginning that this way of standing there is unique. Okay, but just looking at the question there, that they all agree, all comments made, they all agree that mediation has, is the way to go. Everybody wants to do it, but the thing is, of course, the small boys, in the industry can, wants to mediate, but the employer doesn't want. But anyway, we move to another topic about contracts that determining that without any default or by convenience, and it's a lopsided agreement. Now, are there any pending case in the court in respect of this about whether you can do by judicial review to nullify the decision to terminate?
Yes, Tan Sri, at the risk of not making any comments which are sub judice, I believe that there is one particular matter right now going through the courts involving the termination of a contract for national security reasons. Now, the general position, obviously, the government will argue that this is outside the scope of judicial review because it involves a commercial contract between the government and a private party. It's private in nature, does not involve public law. But I think there are reasoned decisions from the Pre-Council that the way in which a public authority behaves, whether or not it's in respect of a contract or other decision-making process, is still subject to the rules of the rules which they are governed by, and that may be subject to judicial review.
Oh, okay. That brings me back to one case. I think 2 years ago, the federal court came up with a decision on a banking case. There's an all-encompassing clause in banking documents that you can't, whatever negligent act that were involved, you can't sue them. Now, can't that principle apply to this? Because we're talking about, like you said, commercial, because the government is arguing this is commercial, there's no judicial review. Now, if you treat that as a commercial document, surely such clause, if you apply that federal court decision there, could be used to strike down such clauses. It's not, I can say now because I would not be subject to sub judice. Habans, you want to come in there, or you want to just leave it to the legal ego? You are a legal ego as well.
No, I'm talking about this termination by convenience clauses. I mean, I think they are quite a bit misunderstood. You see, a lot of contractors feel they're quite unfair, they're quite one-sided. But let's be very realistic about it. I mean, I've been involved in some of them. If I'm the employer, for example, when I started the project, it was actually feasible financially. Halfway through, it's no more feasible. I want to stop it. If I go the normal route, there'll be a repudiatory breach of contract. Then what happens? We all land up going to court, we land up going to arbitration, isn't it? You are a contractor. Isn't it better to have this kind of a clause? If you're going to stop, like, we are married, suddenly we want to go for mutual divorce, why not? So it's better for you because this kind of clauses, there's always a formula for paying the contractor.
Correct.
And the formula is quite good because you can normally, they say, if you look at a KLCC, for example, conditions of contract, you're supposed to be paid within 3 months of termination and all that. wouldn't you rather go for that than instead of fighting the guy for repudiation, going to adjudication, going to arbitration, going to, and leaving the fate of what you have in the hands of total strangers? Adjudicators, arbitrators, and judges are total strangers. They do not know what is actually happening on the ground. So isn't it better to have this guy? Anyway, he's not going to go ahead with the contract at all. Now, the only thing that is always a concern is because it's one-sided, employers make the formula of paying very one-sided. They don't pay you loss of profits. AIC form is the only one that has got loss of profit element there. So now, if you're a contractor, when you're negotiating for a contract and you find this element is missing, try to put it there. If it's not there, then I think you got to hedge it, or you got to hide this 10% or 15% somewhere. You can do it. Those of us who do pricing or contracts, we know how to do it. So I think although on the face of it, it looks a bit unfair, but actually it's not that unfair.
So does the principle of good faith come into this sort of situation?
And of course, good faith, we test, okay, now we know if you're the employer, if you go for termination by convenience, and then because you find it's a bad commercial bargain, you terminate and get another fella appointed, I think their case law.
That's different.
I cannot tell offhand where it is held to be invalid. Okay, where it is held to be invalid is for an improper purpose. Okay, so I think there are grounds where you can challenge it. And I think so far our courts, I don't think so we've got any case law, but there are a lot of foreign case law. Okay.
Well, actually, there is a case recently, a new JC called Purement Venture and Kedah Cement. I think Harban's slide talked about the Berganza principle of good faith.
Principles,
yeah. So the High Court said that kind of duty may not arise in a commercial relationship. It could probably arise in a relationship like Berganza was a employment matter, I think, on a fiduciary or special relationship. Yeah.
So of course, this issue of improper purpose, this is one where I find is a commercial, it's not to my advantage to carry on with the job and then I employ somebody else. That's one. Of course, the other thing, improper purpose, well, I'm touching on one area which I shouldn't be touching is one political party comes to power,
yes.
Gets rid of somebody appointed, and this and that. That is also improper purpose. Although you can contract, you can say it is conclusive, nobody can challenge it. But I think under law, I think it's still subjected to judicial review, and whatever the courts are going to do, they're going to look for it. Is it for an improper purpose? So
which is actually quite happens. It's quite similar to also like the variation clauses, whereby you have a variation omission, which you're fully entitled to under the contract, but then you go and give that work to a different contractor.
Yes.
I think that there is a analogy that can be drawn there.
No, but I think the good thing, ladies and gentlemen, is I think the judges, I think nowadays are a bit more conversant on all these issues.
Yes.
And I think the judges, I'm not saying anything, the judges are willing to listen a bit more and know what is actually, they're willing to go behind. Ada udang di sepalai batu lah. I think they're willing to at least listen. Okay, maybe different levels, they listen to a different level, but they at least listen. And I think it's a very good sign, it's a very positive sign. Gone are the days, it's so one-sided, it cannot be questioned at all and it's conclusive. You cannot even open it up,
Well,
when there's an improper purpose. Yeah.
I always listen to you, whether in a seminar or in court. Which brings to this question. We're talking about termination. So the question is, since you said, the poll we just had is not correct. There's a lot of people suffering there. So my question now is, what should they do if they're terminated? What should they do when they're terminated? If you're a subcontractor, if you're a contractor, what should they do?
No, the first thing to me, as I always keep on telling people is, although we are involved in adjudication, arbitration, this and that, the first thing is talk. We have stopped talking as a nation, even neighbor. We don't even talk to our neighbors. And when it comes to an industry, and we have this mentality, I got money, I got employers who told me off when I was working as a consultant. You work for me, you listen for me, I'm your paymaster. So I told them I'm not a prostitute from Chowkit, So a certain level of professionalism, so you have to talk. And everybody got to realize, because today you squeeze somebody, tomorrow somebody is going to squeeze you. It's guaranteed.
That's why I said
the law of karma will come in.
That's why I said mediation must be made compulsory. So you want to come in here?
Yes, please, Tan Sri, because I agree about talking, and I'm a great advocate of that. I have spent all my time doing seminars saying how to put people like myself, lawyers and arbitrators, out of business. Nobody listens, 30 years down the line. But one of the things I was going to say was that by all means, talking is actually a very, very good thing to be doing now. But talking, in the case of a termination whereby a contractor, for example, is trying to claim for work done, amount of work done, loss and expenses, whatever it is, talking doesn't mean to be going there and banging the table and saying, I want 5 million, and the employer saying, I'll give you 500,000, and then having a horse trade. No, I don't think you have to do that. I think that you should be also, contractors, please be reminded that when you go and talk, give yourself a chance. In other words, have your final account ready. Have your documents or at least your calculations ready so that you can actually justify how much is due. With that, I think that your negotiation position is that much higher. One of the problems that we tend to see, especially in the case of Cpa, is that a lot of times these documents or a claim, whichever way you have it, is just chucked in a big pile and given either to the consultant or given to the arbitrator or adjudicator, and it's like, nah, you deal with it. So I think that everybody has got to do their part. If everybody does their part, all of us here, the four of us here, the four speakers in this webinar, in this session, should be put out of a job. And that would be a good thing for the industry.
No, don't worry. We will still have our jobs. Don't worry.
I don't want the job if you can. It's fine. No, I'm not worried. That's the whole point I'm trying to say. I'm not worried about this
what
job.
I'm trying to say, sorry, one last thing. You see, we have seen people in marriage situation, divorces, coming to amicable agreement.
Yes.
And I feel that is even more difficult. Construction is only money. There is emotions, where people can there talk and we can make them settle things. Why can't we do it in construction where the only thing is money, other than maybe ego lah, I got power, okay. You challenge me.
All right, okay. Now we are getting to the end of the session. We've got 3 minutes, so I'm gonna get you guys to just sort of your parting remark. Now I'll start with you first, Devan.
Well, Tan Sri, just to follow on from what everybody is talking about. In fact, I think if there is a will, there is a way. And at the moment, we have to make the government look at introducing perhaps mandatory mediation, as you suggested. Even their attempt to settle the dispute in the COVID Act says may be settled by mediation. Why didn't they say shall? So yeah, that's what I wanted to say. Yeah. It will help hard-ones as well.
Thank you. Seri?
I think that everybody has got to do their part. I believe that from a contractor's point of view, I said earlier on, get your ducks in order, get your final account ready. I did a webinar in, I think, May of last year. And what I was suggesting was that from that point in time, start getting your final account together. Don't just go in with a number, go in with a number that has got backup. From the employer's point of view and those who are higher up in the food chain, I think we've got to think about the overall project, the health of the project, the ability to deliver the project, and therefore, it's not necessarily all about me against you. It's about what is the project, and of course, dare I say this, there is an even bigger picture, which then goes about our community, our country, our whole world economy. I mean, I can go on and on, but I mean, that sounds like fairy tales to a lot of people. But, it does play into this. That's all I'm saying. I'm sorry. I'm ever the optimist.
Abang, you have the second last word. I have the last.
Okay. No. Only thing is, I apologize lah if I've said anything wrong. Saya minta maaf. Tak ada niat yang buruk. Niat murni lah. Okay. So, I just try to be mean well. Maybe I may be a bit emotional the way I put it, but I have a feeling of what is going on the ground. I thank my fellow panelists, and I also thank Tan Sri and the organizers for giving us this forum, And at the end of the day, we have to help ourselves, Don't expect anybody else. Forget about the powers to be, We have to help ourselves. And the more amicable we keep it, the better is it. So thank you very much.
Okay, thank you. Could I just finish this session by telling a story? when I was a judge in KK. And I was doing really construction cases, right? And these people were throwing bundles and bundles at me. Then, fortunately, I knew this person called Haban Singh, right? I attended a session at AIAC. So I thought, you know, I said, you guys, you would like to settle this amicably. And thankfully they agree. And I phone call to Habans, and within 2 months it was settled. So nothing, you know, I'd like to just end the session, talk among yourself. Everything can be settled. And you know, if you do that, it'll cost you time, your stress, and money. There's always a solution to every dispute. So on that note, I would like to just read one of the comments there, that this session is worth skipping lunch. So I rest my case. Thank you very much, guys. Really privileged to be moderating this session. I hope to catch up with you people in person. And okay, thank you very much. I hand it back to the organizer. Thank you.
Thank you.
Wow, I hope you did not skip your dinner for tonight's show. The riveting discussion was so engaging even after rewatching it for a second time. I hope you can join us tomorrow when we listen to a range of topics from several distinguished speakers and a brand new speaker just for this charity premiere.
And yet we came out of the other side stronger, with lessons learned and a new approach.
There's actually two different views on how this concurrency should be approached.
This is not meant to be exhaustive, of course, but hopefully it will help you to become a better second chair or junior counsel, and eventually you become a lead counsel yourself in the future.
You can also claim for payment outside the scope of the contract.
Finally, the Court of Appeal held that the manner in which the concept of legitimate interest was framed in Cavendish, it had a protean nature because it would allow it to be used very flexibly, and this would create too much uncertainty